The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 984, coming to you on Monday the 28th of September 2020. On this program, I will continue the program I started 2 weeks ago, the compulsory acquisition of land, and this will be part 2. I do apologize that I was not able to be on air live last week Monday for circumstances beyond control. But here goes with the promised part 2. And if according to how the program goes, I determine that a third program would be necessary, I will let you know at the end of this one, okay? Well, I have decided to eliminate preliminaries from this program. And I will merely say to all families which have had recent bereavements, my deepest condolences to you. And I will now get straight into the compulsory acquisition of land, part 2. Just to recap, when I did part 1, I indicated to you that there are 2 laws which basically govern the compulsory acquisition of land by the government. Those laws are firstly the Constitution of St. Vincent and the Grenadines and the Land Acquisition Act. In part 1, I dealt with the Constitution and even indicated to you that as the present Constitution is worded, there are 3 weaknesses in the area of compulsory acquisition of land by government. We sought to have those weaknesses corrected when we had proposed a new Constitution in the referendum of 2009, but the people did not accept the new Constitution. And therefore, the Constitution as it is right now still has those 3 weaknesses. And they are, in a nutshell, firstly, we feel that there is insufficient indication in the Constitution as to the measure of compensation. The present Constitution speaks about adequate compensation, but we had proposed that that should be expanded, not accepted. Secondly, the present Constitution is based on the foundation of the Land Acquisition Act, which specifies that when compensation is to be assessed on behalf of a landowner whose land has been compulsorily acquired by the state, that compensation has to be assessed at a date 12 months before the date of acquisition. And thirdly, the existing Constitution says the compensation paid by the government should be paid within a reasonable time. We had proposed that the Constitution should say that the compensation should be paid within 1 year. Subject to that, I dealt with the Constitution. So in this program, I will deal with the other law which governs the compulsory acquisition of land, namely the Land Acquisition Act. The Land Acquisition Act is to be found as Chapter 322 of the Revised Laws of St. Vincent and the Grenadines, 2009, Chapter 322. And for those who are really interested in the topic and would like to read that law themselves, just get in touch with a lawyer with whom you are familiar and ask that lawyer to let you have a read of it or even photocopy it for you. It's 32 sections, not very, very long. And I will commend it to those who are interested deeply in the topic and would like to see what the law actually says. Now, on this program, I hope I will be able to get through reading at least the first 6 sections of the Land Acquisition Act. If I don't, well, then I definitely will go into program number 3 next week, DV. Now, let me say this by way of an introductory comment. The land law we have in St. Vincent and the Grenadines is based on the land law we got from England. Therefore, we are operating basically English legal principles of land law. Those students who have studied land law at university would have been baffled, confused in some cases, by the history of the development of English land law. I found it extremely fascinating because when I went to university, I had been a history student. I loved history in my GCE O levels and A levels. In fact, I'll boast a little bit. I got a distinction in history in my O levels. No. So I loved history. And English land law is extremely historical. For a proper appreciation of the development of the law in England when it comes to land matters, one would benefit from a knowledge of early English history. Of course, we don't have time for that, and this program is not the place for that. But the evolution of English society, particularly the class structure in England as it evolved from the earliest days of the Norman conquest in 1066 AD right up to now, is entwined with the development of the law of the land. This program, as I indicated to you when I did program on the first part, was specifically requested by a very good friend of mine, Brother Oti Mayers, because of a current controversy in St. Vincent and the Grenadines right now about the acquisition by government of a parcel of land at Murray's Village in Kingstown. In order to appreciate what the law says as opposed to what we think it ought to say, we need to know the basic philosophy of English land law. And that is that all land belonged originally to the Crown. And all land in England has devolved from the Crown. When it comes to places like St. Vincent and the Grenadines, which were colonized by England, then quite literally, when the British got St. Vincent and the Grenadines ceded from Spain, the theory was that every square foot of land in St. Vincent and the Grenadines belonged to the British Crown. And those who listened attentively to the expositions which are given from time to time by Dr. Gonsalves, the Prime Minister, on the history of the acquisition of lands where the Argyle International Airport is built. If you follow what Dr. Gonsalves has been teaching, he explained to you that when the British got St. Vincent, various chunks of St. Vincent were given to various members of the British aristocracy. In fact, Argyle is part of the lands given by the Crown to the Duke of Argyle. So that the fact that there were native peoples living here, the Garifuna and the Kalinagos, meant nothing to Europeans when they colonized places like the Caribbean. If an island was said to belong to Spain, every piece of it belonged to Spain. An island was said to belong to France, the whole island belonged to France, regardless of who the French met living there before them. Similarly, when the British came here and took St. Vincent or granted St. Vincent and Grenadines by negotiation, they simply assumed the ownership of the whole place. That concept of the Crown owning the entire territory underlies the law of the land in St. Vincent and the Grenadines. And therefore, there is a principle in law that the Crown can compulsorily acquire any piece of land it wants in St. Vincent and Grenadines up to now, after 40 years of independence, once it is required for a public purpose and once the Crown intends to pay compensation to the owner or owners of the land. So that is the first thing we have to understand. You may say, oh, I own 3 acres of land, or I own a lot of land, or I own 10 acres of land here and there. Fine. But your ownership and my ownership of land which we have bought is subject to the right of the Crown. The right of the Crown, and Crown means government, to take that land from us anytime they want to be used for a public purpose and upon payment to us of reasonable compensation. Therefore, whenever any controversy arises involving the government acquiring private property, attention has to be turned to the Land Acquisition Act, because the government has to act in accordance with the law. The government cannot ignore the law and do what they feel like. They must be guided by the law. That is, according to the Constitution, the land has to be taken by the government for a public purpose, and the government must have the intention to follow the legal mechanisms to make sure the owners of the land are paid their fair compensation. Therefore, in any controversy, what matters is whether or not the government can show that the government acted in accordance with the law in acquiring a particular piece of land from anybody. But as to the right of the government to acquire the land for a public purpose, that cannot be argued. The Constitution says the government has that right. It is based on history and on the notion that ultimately all land is held on a tenure from the Crown. Let me say as an aside, suppose you have a piece of land which is yours. You have bought it or you have inherited it. Or somebody has given it to you like a parent. So it's your land. You have a title deed for it. You intend to build a structure on the land. You start to dig a foundation. When your workmen have dug down to a certain level, suppose they suddenly discover valuable minerals on your land. You think those minerals belong to you? No. Those valuable minerals belong to the Crown. The Crown might share it with you, but basically, mineral rights are vested in the Crown and can only be alienated if the Crown signs a document saying they're giving you the right to the minerals found in the soil. So even the land we call our land, we have a title deed for it. Huh? Where there are minerals found, suppose for example tin or bauxite or gold is found on our land, it's not ours. As a logical extension of the principle that all land ultimately belongs to the Crown. So with those preliminary comments, let me now turn to the Land Acquisition Act, because this is the law which the government has to follow if it is going to acquire any land compulsorily from anybody. Now, I may slip and not say compulsory from time to time, but that is what I mean, because there is nothing to stop the government buying land from anybody. There's nothing to stop a landowner negotiating and selling a land to the government. That happens all the time. But you know, sometimes the government might have a road project. It wants to build a highway or extend the highway, widen the highway, or widen a corner in the highway. And in order to widen the corner or to extend it, the government has to take bits of land belonging to the landowners which lay along that highway or in that corner. Government can do the necessaries, follow the law, and go and widen the road. But the landowners whose lands would have been taken to widen the road are entitled to receive compensation. It might take them a long time to get it because the Constitution doesn't say within what time they have to be paid. All the Constitution says within a reasonable time. So I'm dealing with land that the government wants and the landowner does not necessarily want to sell or has not even been approached with an inquiry as to whether he or she or they want to sell. Excuse me. All right, so we now come to Chapter 322, the Land Acquisition Act. Section 1 gives the title of the Act. Section 2 gives the interpretation of two terms. One, authorized officer, and two, person interested. And this is what it says. Authorized officer means any person who may be appointed as such by the Governor General for the purposes of this Act. And for certainly the last 40 years, the chief surveyor has been, or the successive chief surveyors have been appointed by the successive governments as authorized officers for the purpose of administering the Land Acquisition Act. Person interested means every person claiming or entitled to claim compensation under this Act. Now, we now get into the substantive sections of the law. I will read exactly what the law says and intersperse with appropriate commentary. And again, I would plead with those who are really interested in the topic, kindly listen to the words of the Act. Because law is not a question of what you think it is. It's not a question of your opinion as to what the law is or ought to be, or whether you like it or not. Law is law. It's what is written in the law books as interpreted by the courts. All right? So, Section 3, subsection 1. If the Governor General considers that any land should be acquired for a public purpose, he may cause a declaration to that effect to be made in the manner provided by this section, and the declaration shall be conclusive evidence that the land to which it relates is required for a public purpose. Who is the Governor General? Well, that is a trite question. But basically, when laws refer to the Governor General, those laws mean the cabinet, the government of St. Vincent and the Grenadines for the time being. So Section 3.1 is saying that if at any time the government considers, they decide that they want any piece of land for a public purpose, I'll come to that. He may cause, well, of course, the Governor General presently is a female, so for he, you understand that to mean she, which really means the Cabinet. May cause a declaration to that effect to be made in the manner provided, so that basically all the government has to do is to say by a declaration, which you will shortly hear is to be published in the Gazette, to say that we want this parcel of land for X public purpose. Subsection 2. Every declaration shall be published in 2 ordinary issues of the Gazette, and copies thereof shall be posted on one of the buildings, if any, on the land, or exhibited at suitable places in the locality in which the land is situated. And in the declaration shall be specified the following particulars relating to the land which is to be acquired. A, the parish or district in which the land is situated. B, a description of the land giving the approximate area and such other particulars as are necessary to identify the land. C, in cases where a plan has been prepared, the place where and the time when a plan of the land can be inspected. And D, the public purpose for which the land is required. 3, and this is the fundamental piece of this law. Subsection 3. Upon the second publication of the declaration in the Gazette, the land shall vest absolutely in the Crown. My brothers and sisters, the acquisition of land by the government is achieved as simple as that. The government just has to say, we want this piece of land for X public purpose, and publish it in 2 issues of the Gazette. And the law says, when the second notice is published in the Gazette, the land automatically belongs to the government. Now, as you would see, my time for this program is practically up, so that it will be necessary to go into a third part, so that I hope that next Monday, DV, I will be able to do part 3 and read you the rest of the Land Acquisition Act. Because if you don't know what the law says, it is easy to get into an argument as to what you think the law ought to be. Now, for those of us who have held the office of Attorney General, this is something to which we are accustomed, because one of the functions of an Attorney General is to advise the government on the legal procedures which have to be followed when the government wants to acquire land for a public purpose. So that I hope, as I said, those who are really interested in the topic and want to really know what it is, get in touch with the lawyer and ask them to lend you their copy. Well, lawyers don't like to lend out their books, but ask the lawyer to photocopy chapter 322 for you. And you read it for yourself, and you will see that all the government has to do, if it requires land for any public purpose, is to publish a notice in 2 issues of the Gazette, 2 ordinary issues. And when the second notice is published, I think I should read that for you again because it may be startling in its effect. Subsection 3 of Section 3. Upon the second publication of the declaration in the Gazette, the land shall vest absolutely in the Crown. In other words, the land shall belong to the government. Absolutely. Subject to the payment of compensation later on. And just, I think I should, in all fairness to you, to save you the suspense, I took the trouble to get myself copies of the 2 government gazettes published in relation to the Murray Village land. The first notice was published on the 28th of July, first publication, and the second notice was published in the Gazette on the 5th of August 2020, second publication. I will read them to you on the next program, but as I have seen, as far as I have seen, the government has complied with the law as it is written. Perhaps they have not complied as some persons might have wished them to comply, but they have followed the law because I have seen and I have in my hand the 2 gazettes in which the first and second acquisition notices have been published, and basically this is it. So that disputed land belongs to the government now. And I would only say this: persons who are, as has been alleged, are harassing Dr. Murray and his family are playing the fool and should desist from any harassment of the doctor or his wife or any member of the family. And the land is not theirs, it's government's land. They have not been parceled, the government hasn't parceled it out yet and given crown grants to anybody. No deeds have been given to anybody. So the land is government land. And people should refrain from going and harassing Dr. Murray and his family. This is something for legal processes. If you're one of those in whose favor, or you think you're entitled to peace, you've been living there and so on, well, wait your turn, wait for the processes. But don't go and say you're harassing the man and doing all sorts of things. And Doc, I would plead with you, don't do what you threatened in your Facebook publication to do. All right? Otherwise, the same law, you will get in trouble. You will get yourself in trouble. Don't let them harass you to those sorts of threats. But I look forward to being of further service to you next week, Monday, DV, for another presentation in this Public Service Nation Building series, The Law and You, for part 3 of this topic, the compulsory acquisition of land. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.